Hi, I'm John Hayes. I'm a bankruptcy attorney in Southern California. I'm a certified specialist, and I teach at the University of West Los Angeles School of Law, where I've taught for nearly 30 years now. I've taught a basic bankruptcy class there probably 25 times now, and I'm teaching one this semester, the spring semester of 2021. So the video is designed to help my students. This will give them a chance to review what we discussed in class. And what I'm going to talk about today is one of the most important concepts in the entire bankruptcy world, which is called property of the estate. And the bankruptcy code says in section 541A, it gives us the definition of property of the estate. It's a very important definition. And what the definition is that property of the estate consists of all legal or equitable interests of the debtor in property wherever located at the moment of filing. So when you give all your papers to the clerk stamps filed, the case begins, a bankruptcy estate is created, and everything that the debtor owns is transferred into this estate. A trustee is appointed. The trustee's job is to sell the property and give the money to creditors. We need to remember that bankruptcy was invented to help creditors sell the debtor's property. The idea is that if we have one person selling everything and it's not a fire sale, the value can be maximized for the benefit of everybody. And the proceeds can be distributed to creditors equally. So it slows down this, what's generally called this rush to the courthouse. Whatever creditor gets a judgment first can seize everything. And so what is it? What is property of the estate? Typically, I ask clients call me, potential clients call me. I say, what do you own? Oh, I don't own anything. I've learned that what they think I'm asking usually is whether they own a home, do they own real property? Some people think that if you have no equity, that means you don't own it. They'll say, oh, the bank owns it. What you own, what you own? All legal and equitable interests in property wherever in the universe it's located. So that's what this is about today, is what does that mean? How do we know? How do we know what you own? All right, so we start with the easy part, which is tangible property, things you can touch. Your clothes, your furniture, your dishes, the glasses on your head, my hockey equipment, my computers. I hesitate when I say that because I think this computer is actually owned by my firm, Resnick's Maradi. Do I have a legal or equitable interest in this computer and this video camera? And, well, how do we figure that out? The bankruptcy code doesn't tell us how you figure out what somebody owns. But there's a Supreme Court case that came down in 1979 called Buttner versus United States. I just, let me pull it up on my computer here. My company, my firm's computer. Buttner versus United States, 1979. The Supreme Court said, we don't know what property is either. In that case, the issue was rent. Who owns rent? Who has the right to this rent? Rent was collected from rental property. Can the trustee distribute it to unsecured creditors, or does the trustee have to give the money to the bank who has a mortgage on the real property? And the Supreme Court said, we don't know the answer to that either. But what we'll tell you is that the answer is determined by state law. In that case, was North Carolina. So I live in California. If I file bankruptcy, what I own is determined by California law. All right. A good example, one of the next case that I discussed with my class that I discussed this semester is a case called Dalton. In re Dalton, it's a Arizona case from 1992. And in that case, the property that they were arguing about was a lottery ticket. So when the case was filed, this lady owned a lottery ticket. And guess what? It won. You know, when the clerk stamp filed, this lady had a lottery ticket. She probably had some money in her pocket, you know. She had a purse. It's all property of the estate, including this lottery ticket. So as soon as she filed bankruptcy, everything that she owns, including her purse and that lottery ticket and the money in her purse, is property of the estate. The trustee is supposed to sell it. I should say, just so the panic level doesn't get too high, that 97% of all cases are what we call no asset cases. Doesn't mean there's no assets. What it means is there's nothing that the trustee can sell because everything that's owned is exempt or has no equity. All right, anyway, this lottery ticket, the trustee found out about it and the trustee said, give me this property estate, I want my lottery ticket and the proceeds. And what the debtor said is, actually, I only own half of the lottery ticket. My mother owns the other half. See, we bought the lottery ticket together. My mother didn't file bankruptcy, only I did. So my legal and equitable interest in this lottery ticket is only half. The trustee said, no, I want the whole thing. I think you own the whole thing. She said, no, my mother owns half. How do you figure that out? So I've given you the rule already. The rule is that whatever Arizona law says, this case was in Arizona, whatever Arizona law says, that's who owns the ticket. And in Arizona, and I believe in California also with lottery tickets, is the lottery commission will not recognize any owner of a ticket other than the person in possession of the ticket. Unless there's some sort of court judgment. If the mother and the daughter sued each other and the court said, yeah, this is half one, half the other, well then fine. Otherwise, the law in Arizona is this lottery ticket is owned by whoever is in possession of the ticket. Well, then whoever the debtor was in possession, the entire ticket is property of the bankruptcy estate. What about mother? I mean, why don't we think about mother for a minute? She says, well, we had this deal. Maybe mother put up half the money. Maybe they put in $50 each. So the mother says, we have a deal. In bankruptcy parlance, that means that the mother has the right to half the money, but that's only a debt. That's something they agreed to before the case was filed. Mother has an unsecured debt. Mother has the right to collect money from the debtor, but the ticket belongs to the estate. All right. There's another case that I've always loved talking about, a case called Tripp. In re Tripp. It's a case from Iowa. The debtor owned a whole lot of marijuana. Now, in 1998, marijuana was a lot more illegal than it is now. The debtor didn't disclose that he owned all this marijuana. You know why? Because he'd go to jail. So the trustee found out about the marijuana. Do you think the trustee said, hey, turn over that marijuana to me? Well, possession is a crime. Trustees can't do things that are a crime. So the trustee couldn't get the marijuana, obviously couldn't sell it. So whether the debtor owned it or not is completely irrelevant to the bankruptcy estate. And the bankruptcy judge said, because you owned this marijuana and you didn't disclose it in your schedules, you committed a false oath. You didn't disclose everything you own, and therefore you don't get a discharge. The discharge was denied, which means the debtor still owes whatever they owed before they filed. Under Iowa law, the debtor owned that marijuana and had a duty to disclose that he owned it, even though it couldn't possibly do the bankruptcy estate any good. All right. What about, let's move on and we've talked about everything you own. What about community property? If I file bankruptcy by myself, my wife doesn't file with me, I'm the debtor. All of my legal or equitable interest in property wherever located becomes property of the bankruptcy estate for me. The bankruptcy code says that the estate includes 100% of my interest in community property. 100% of community property is property of the bankruptcy estate of either spouse, if only one spouse files. What if one spouse files, all the community property goes into that estate, a week later, the other spouse files? I wish I wouldn't bring up things that make this more complicated than I want to get into, but the second spouse doesn't own any interest in community property anymore because it's all property of the first estate. All right, but anyway, 100% of the community property is property of the estate, even though only one spouse filed. So that raises two questions. If the trustee sells it, does he have to give half of the proceeds to the non-filing spouse? And the answer to that is no. That why really does go beyond the scope of this video. But the second question is, how do you know whether it's community property or not? So the rule in California is that all property acquired during the marriage is community property, except property acquired by gift, bequest, devise, or descent. So basically by gift or inheritance, property acquired during the marriage is community property unless one spouse or the other acquired the property by gift or by inheritance. Under California law, that gets really murky. If my wife owns a building and there's a mortgage on it and she's paying for the mortgage out of her paycheck, well, her paycheck is property acquired during the marriage. That her paycheck is community property. She's taking some of our community property and paying her mortgage. There's some argument that that building that is her separate property just kind of became a little bit of community property. Who knows? Ask a family law attorney that, but for our purposes, to the extent there I have a legal or equitable interest in her building, my wife's building, my wife who's not filing. If I own a legal or equitable interest in her building because she's been taking her paycheck and paying the mortgage with it, then that legal or equitable interest is property of the estate. All right. So let's go on and think about property beyond buildings and land and stuff you can touch, your clothes, your furniture. I think it's really important to think of property in terms of rights. If I have the right to something, even that lottery ticket gave that lady the right to collect money. The lottery ticket by itself is just a piece of scrap paper, you know. It's the right. So let's think about, what about a right to commission? If I'm a salesman, I'm a real estate salesman, and I have a deal. I have an escrow that's going to close next week. If I file today, and the escrow closes next week, is the commission that I'm going to get paid next week, is that property of the estate? And the answer to that is yes, to the extent that I have a legal or equitable interest in the property when the clerk stamps filed. So we have to think about that. Well, I have the right to the commission, but not today. I don't have any right to get any. I can't call somebody and say, where's my check today? The escrow has to close, and that's going to happen next week. So as of today, I was going to start to say I have no right, but that's not true. I have the right to collect that commission if the escrow closes. I have a contingent right to collect that escrow. The contingent right is property of the estate. The legal or equitable interest in that commission is subject to some conditions. But I could actually sell it. I mean, I assume I could sell it. What about an attorney? If I take a case on contingency, well, today, I don't have the right to any money. I can't tell my client to give me money, right? I have to go to trial, win the case, and collect the money. Then I get the money. So if I took a case 6 months ago and trial is 6 months from now, and I file bankruptcy today, is any of the money that I might receive a year from now property of the bankruptcy estate? And the answer is yes. A legal or equitable interest in the money that I might receive 6 months from now is property of the estate. Property acquired after the bankruptcy is filed is not property of the estate. But we have to look and see whether there's a legal or equitable interest in the property today. This morning, I did some work for clients. So I wrote down my time, and I have the right to send them a bill. And I have the right to get paid, right? That's called accounts receivable. They agreed that if I do work for them, they would pay me a certain amount of money. Well, I did work this morning. I haven't billed them yet. I haven't collected it yet. I may not collect it. But my right to receive that money today, I have the right to receive that money if I send a bill and if he pays it and if I collect it, then I'll get the money, you know. And so the right is property of the estate. All right. So let's go back to the commission, the sales commission, and the contingency fee lawyer. I've put on bunches of other tests, by the way, that what about a bonus? You know, one of the attorneys in our office, we say, well, if you work so many hours per year, we'll give you a $10,000 bonus. So we're in the middle of the year. Right now, they didn't work all those hours. That person didn't work all those hours. That person has no right to a bonus right now. But if they get the rest of the hours by the end of the year, then they'll get to the bonus. So that person has the right to get a bonus if he does the rest of the work after the case is filed. So how does that work? So let's think about again. We'll talk about the contingency, the salesman's commission, and the bonus. The way it works is bankruptcy code doesn't say this. This has come through court cases. What the courts say is that the property of the estate is allocated between the work that was done before the case was filed and the work that was done after the case is filed. So in the contingency fee case example, if I'm the lawyer, I did the work for 6 months before I filed, and then I do more work for 6 months after I filed. So the right to collect for the work that I did after I filed, that's not property of the estate. That's my money. All right, that's my fresh start. All right, but the courts would allocate it. So I did half the work before, half the work after. The money that I get someday after I file would be divided 50-50 between the estate and between myself. Same with the commission. If the real estate agent, and we have to kind of think about that, the real estate agent, how much work did the real estate agent do? If the escrow is going to close next Thursday, the real estate agent has been working on trying to get this property sold for the last 6 months. There's still a lot of work to be done, I think. Real estate agents work really hard there the last week trying to get that escrow closed. But anyway, you can get my point. With the bonus, again, if it's the middle of the year, or let's say it's 10 months into the year, well, we still got to wait to see what happens in the last 2 months. But if it happens, some of that bonus that you receive at the end of the year was earned before you filed. There is a legal or equitable interest to, in my example, 10/12 of that bonus as of the moment of filing. All right. How about litigation? So I'm hit by a bus, and by the way, let me go back to what I was just talking about. Remember my example of the accounts receivable? I did work this morning. So I did an hour's worth of work. And I have an arrangement with my client that they'll pay me $350 an hour. Well, I did an hour's worth of work. They owe me $350. That right to collect $350 belongs to the bankruptcy estate. We don't allocate it unless there was some contingency where maybe the person didn't have to pay me unless something else happened. And that something else happened after we filed. The right to receive it is property of the estate. What about suing people? Boy, this comes up all the time. So if I'm in a car accident and I'm injured, I lose time at work, and I sue the person that ran into me. Let's say it's a city bus. I sue the city, and I say, you caused me a lot of damages. And I wish now I would have thought of a simpler example. Let's say it, anyway, let me just leave it at that. I am suing somebody for something that they did before I filed. My right to collect the damages or whatever it is, my right to collect that is a legal or equitable interest in property at the time I file. Now I have to sue them, I have to hire lawyers, I have to pay costs, there's costs involved getting, actually collecting it, well, that's the trustee's problem. My right to collect from this person is something that I own as of the moment of filing. All right. What about, what happens? Let me just finish on that. The litigation is when I'm talking to a client, we're going through all the schedules, and one of the questions in the schedules is, what are you suing anybody? And I say to the client, well, are you suing anybody? No. What I ask is, well, do you want to sue anybody? They say, well, yeah, I've been, I was locked out of I was improperly fired by my last boss. I would like to sue my last boss because he fired me improperly. That's a right. I said, why don't you sue him? Well, I don't have any money. I can't afford a lawyer. Well, that's the problem, but your right to sue your last employer is property of the bankruptcy estate. It's a legal or equitable interest in property. All right, so I actually will say to clients, well, if I could get you a free lawyer, is there anybody you would sue? That's, boy, they start thinking, yeah, my ex-wife, the landlord, we call those claims. You have rights to sue people. Maybe they're hokey, maybe they have no chance, maybe they have a big chance, whatever. The right to sue somebody is a legal or equitable interest of the debtor in property wherever located. All right, so let's go on a little bit. What about when you own property with somebody else? Now, if it's a spouse and it's community property, then 100% of the community property is property of the estate, right? We talked about that. But what if it's, I was going to say partner. I yell at my students, I don't like that word partner. Don't say partner. Unless there's a partnership, don't say partner. So let's call it a co-owner. My brother-in-law and I decided to buy a condo in Big Bear, and we own it 50-50. All right. I file bankruptcy. What is property of the estate? My half of that condo is property of the estate. The trustee can't sell the other half. As soon as I say that, there's actually an exception to that. The trustee could force a sale of the entire condo, but the trustee would only be able to keep half the proceeds. He'd have to give my brother-in-law his half of the proceeds. All right. I've mentioned I'm a partner in a firm called Resnick Hayes Maradi. There's three of us. So let's just make believe we own it. We own the partnership. A third. Let's say, the partnership has a lot of assets. It has a lot of accounts receivable, that's for sure. And it has desks and chairs and cases and equipment, and it owns. I don't own anything that Resnick Hayes Maradi LLP owns. It owns that property. Whatever Resnick Hayes Maradi LLP owns is not property of the estate. what is property of the estate is my partnership interest. Well, how do you know what that is? Well, you have to look at the partnership agreement. Let's make that a little bit easier. Let's say it's a corporation. We decided to, my two partners and I decide to incorporate our firm. We form a corporation, we transfer everything that the partnership owns into the corporation, and the corporation issues us stock. 1,000 shares to Matt, 1,000 shares to myself, and 1,000 shares to Roxana. What I own is 1,000 shares of stock. I have no legal or equitable interest in the property that's owned by the corporation or the property that's owned by the partnership. Or if, this condo in Big Bear that I'm going to buy with my brother-in-law, we'll form an LLC, a limited liability company. It will own the condo. I will own 50% of the LLC. The trustee can sell my 50% of the LLC. Can't sell necessarily, can't sell the condo. All right, it owns that property. All right, let me look at my notes here. A couple more things, really two more things, I think. What about property where there's restrictions on transferring it? So what does that mean? If I own a sports bar. I always wanted to start a sports bar. I form a corporation. I'll forget that. I own a sports bar. And the sports bar, I own it. I didn't incorporate it. So I don't own the building that the sports bar is located in. I lease the building. All right. The lease says that I can assign the lease. If I want to sell the sports bar, I can assign the lease to whoever buys the sports bar. But the lease says that the landlord has the right to approve whoever I sell the business to. The question is that binding? I own the rights to the lease. I own the sports bar. The trustee can sell the sports bar. Can the trustee sell the lease? Well, sure. But the lease says that the landlord has the right to approve the buyer of the lease, or in the legal world, what we would call the assignee. Is that restriction on transfer binding on the trustee? The answer, generally speaking, is yes. Unless the restriction is something which, for practical purposes, really prevents the transfer at all. Those kinds of restrictions generally aren't enforceable. And a restriction that is predicated on filing bankruptcy is almost never enforceable. But again, let's say Resnick Hayes Maradi, we each own 1,000 shares of stock. So if I have a deal with Matt and Roxana that says, if I want to sell my 1,000 shares, I have to offer it to them first. Is that binding on the trustee? The answer is yes. He would have to offer it to them. Now, again, if our agreement was, I'll never sell my stock except to one of the two of them, that's not binding under California law. So it would not be binding under bankruptcy law. But to the extent that it's binding under California law, it's binding on the trustee. All right. All right. What What happens when you don't tell the trustee? So the debtor, if I file bankruptcy and I own a condo in Park City, Utah, and I don't tell the trustee that, and the trustee finds out 5 years from now, well, the case has been closed. Can the trustee reopen the case and sell it? And the answer is absolutely yes. When the legal or equitable interest that I own at the moment of filing, that's property of the estate. Whether I disclose it or not, it's still property of the estate. So if the trustee finds out that it's property of the estate 5 years after I file, it's property of the estate. The trustee can sell it. All right. I think the last thing I'll talk about under this category of what is property of the estate is this concept called abandonment. And that's sort of a technical word that we use a lot. That's why it's good to talk about it. Is the property that goes into the trust, into the bankruptcy estate, stays there until the trustee abandons it. Now, the bankruptcy code says that when the case is closed by the bankruptcy clerk, if there's anything still in the estate, it's abandoned back to the debtor. All right, the trustee could abandon property before the case is closed. So a good example of that is let's say my condo on Big Bear. I tell the trustee, I have this condo, it's worth $100,000 and I owe $120,000 on it. The trustee can't sell it because he'd have to give all the money to the secured creditor, the lender. There's nothing left that the trustee could use to give to unsecured creditors. So the property, though, it's still property of the estate. And it stays property of the estate until it's abandoned. But can the trustee abandon it before the case is closed? And the answer is yes. But there has to be a notice, and the court has to approve the abandonment. Once the property is abandoned, it's no longer property of the estate, and it reverts back to the debtor. I should throw out one last thing. I may have already mentioned it, but I'm a little concerned about freaking people out listening to this, that literally 97% of all Chapter 7 bankruptcy cases are what we call no asset cases. That doesn't mean the debtor has no assets. That means that all of the assets that the debtor has are exempt or has no equity. And your clothes and furniture and dishes and the pictures and papers you can see in my office here, that's all exempt. So don't freak out. On the other hand, when people call me, hey, John Hayes, I want to file bankruptcy, and I start asking them about their property. What do you own? And people get annoyed at me. They want to tell me about their creditors, and I need to know what you own so I can advise you what the chances are that you'll lose it or not. So that's property of the estate, Section 541. If you like this video, it is sort of designed not only for students, but for new lawyers and certainly lawyers who are thinking about getting into the bankruptcy arena and filing Chapter 7 cases. If you like the video, click the like button on YouTube. If you have any questions, I'm happy to try to give you an answer. And thanks for listening to me today. Bye-bye.